president power has been classified into different heads. See, normally he is an executive. Okay. First of all, he is an executive. So even though he is executive, he has different kinds of powers, and these are the classification. He is an executive. So whatever power he has is holding on the purview of he is an executive, but it has different types also. That is legislative power, executive power, judicial power, financial power, diplomatic power, military power. These are the different classification that the president can have. Okay, but there are certain functional important powers of the president: ordinance making power, pardoning power of the president, veto power of the president, emergency powers of the president. Okay, so today we will discuss one by one. We will start with the emergency powers. Okay, so before going to the emergency power, you have to understand certain things. Okay, so there are many articles related to president, but now I am taking the articles that is related to this particular lecture. Okay, so article 53, 74 and 42nd Constitutional Amendment Act, 44th Constitutional Amendment Act, article 78 and 143 are related to the present lecture. Okay, so what is article 53? What article 53 said is, the executive power of the union shall be vested in the president. That is, the power of the executive power of the union government is vested or given in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. That is, article 53 said that the president is the executive power of the union. Okay, this can be either exercised by him directly or through officers subordinate to him. These officers include all the union government office, includes the prime minister office, council of minister office, district collector office, every office under the Union of India or includes under this category. Okay, so article 53 tells that there is the executive power of the union government is vested in the president. Okay, he can directly use this power or he can use his power through subordinates. Okay, but article 74 talks about, article 74 talks about there shall be a council of minister with the prime minister as the head to aid and advise the president. That is, the executive power of the union is vested in the president, has to be aided and advised by the president. But what the missing here is whether the aid and advice is binding on the president or not. See, the 53, the power of the executive is given to president. Article 74 talks that aid and advice, there should be a council of minister headed by prime minister to aid and advise the president. But whether the advice is binding or not, whether the president should compulsorily take the advice or he cannot pay here to the advice of the council of ministers. So that question arose. The president, Dr. Aditya uses this power, presidential reference 143, article 143 of the constitution. This is the power of the president to require the opinion of the Supreme Court. So he made that reference, presidential reference to the Supreme Court, whether who has the real power, that is either the council of minister headed by prime minister or the president. So the Supreme Court take the reference and it has given its opinion that according to the convention means customs, okay, which is equivalent to the constitution. That is, convention means that is customs or practices has been for a long time, which is equal in force, equal to constitutional provision. If what power the constitutional provision has, the same power the convention also has. Okay, since we are following the parliamentary form of government, it requires the two executives, dual executives. One is de facto, another one is de jure. De facto means real executive, de jure means nominal executive. Okay, so as per the parliamentary convention, Supreme Court take the view that de facto is the council of minister headed by prime minister, whereas the de jure, the nominal head, is the president. Okay, I hope as of now you are clear about the powers. See, article 53 talks about the executive power of the union government. It is vested in the president. Article 74 talks about there is a group called the Council of Ministers headed by Prime Minister to aid and advise the president. Whether this advice is binding or not is the question. Then the Supreme Court gave the reference. We are following the parliamentary form of government. Okay. So in that, de facto and de jure, two types of executives will exist. So the de jure is the president, since the parliamentary form requires that. Okay. So the de facto is the Council of Ministers headed by Prime Minister. They have the mandate of people, right? So after Supreme Court giving this representation, see, it is not exception 253. It should be read along with Article 53 should be read along with Article 74. Okay. Article 53 should read along with Article 74. See, Article 53. Article 53 tells that executive power of the union. Executive power of the union. Okay. The executive power of the union is vested in the president. Is the power the union executive power is given to the president. He can administer he can use this power directly by him. He can use the power directly or indirectly. Indirectly means the officers subordinate to him. It includes Council of Minister office, other government official offices, all public offices come under the government of India. He can use. Okay. So this is what Article 53 said. But Article 74 says that there is one group called the Council of Ministers headed by Prime Minister. Okay. This group has to aid and advise, that is help the president in exercising his power using Article 53. But the president, the problem arose in the first term itself. That is the problem between the Rajendra Prasad and Jawaharlal Nehru. So the Dr. Rajendra Prasad approached, that is using his presidential power, Article 143 has required the opinion of the Supreme Court in this issue. So Supreme Court given that the aid and advice given by the Council of Ministers headed by the Prime Minister is binding on the president, because we are following the parliamentary form of government. In parliamentary form of government, there are two types of executives. Nominal executive. Nominal means he is the head but not having that much powers. Okay. Nominal head and real head. Real head is the Council of Ministers headed by Prime Minister, because they are directly elected by the people. So they have the de facto, that is they are the real rulers. Okay. So whatever the advice given by the Council of Ministers headed by the Prime Minister is binding on the president. So this was the opinion of the Supreme Court. Okay. So after the opinion of the Supreme Court, in the 42nd Constitutional Amendment Act and 44th Constitutional Amendment Act was inserted through these articles. So in the 42nd Act, the Article 53 was modified like this. See, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, that is the President, in the exercise of his function, act in accordance with such advices. Now it was made constitutionally by 42nd Constitutional Amendment Act. So after that, 44th Constitutional Amendment Act made some more changes. The President can send the advice back to reconsideration once. But if the Council of Ministers send the same advice again to the President, then the President must accept it. That is, what it tries to do is, see, Article 53, the executive power of the Union is with the President. Article 74, Council of Ministers will give aid and advice, right? Aid and advice to the President. 42nd Constitutional Amendment Act made it obligation for the President. Okay. Made it obligation for the President. That is binding of the advice. 44th Constitutional Amendment Act made one small changes. That is, if the Council of Ministers given advice to the President, then President feels that it is not good. So he can send back the advice to the council of minister to reconsider once. If the council of minister again send the advice either with the changes or without the changes, the president has no choice, he has to accept. So that was introduced by 44th constitutional amendment act. Okay. uh, I will again summarize the things for the better understanding. Okay. See, article 53, executive power of the union. Okay. Executive power of the union யார்கிட்ட இருக்கு? president கிட்ட இருக்கு. ஓகேங்களா? It is in the president. Article 74, article 74 talks about there is a one group called council of minister headed by prime minister to aid and advise the president. Okay. Supreme Court gave the opinion that this aid and advice is binding. Okay. But only in the 42nd Amendment Act 1976 only it was made constitutionally, right? The aid and advice, okay, the aid and advice is binding on the president. It was inserted into the constitution itself. Okay. Then 44th Amendment Act made another change. That is, see, 53 plus 74 should be read together, given by Supreme Court. This was done constitutionally by 42nd Constitutional Amendment Act. 44th Constitutional Amendment Act made one changes in that. That is, whenever Council of Minister give advice to the president, he can, if the president feels it is not good, then he can send the advice back to the Council of Minister to reconsider. If the Council of Minister can make changes or cannot, that is without changes, if they send again to the president, then president has to accept. He has no choices. Okay. So this is the summary of what we have seen till now. Okay. See, it is not exception. What the Supreme Court said in the judgment has been made constitutionally. Okay. That's all. There is nothing. Okay. So what I am trying to say, and what you want to understand is, wherever you read that is the satisfaction of the president, it is not the satisfaction of the president, whereas it is the satisfaction of the council of minister headed by prime minister in theory, that is by constitution. But in practice, this power is literally exercised by the union cabinet, that includes the head as a prime minister. Okay. See, understand it practically, very simple. Today, the government, right? And our prime minister is Narendra Modi, right? He has the cabinet ministers. They are making all important policy decisions. But the council of minister group is somewhat wide than cabinet. It will go around 70. Okay. But the cabinet ministers only 4 to 5 or maximum 7, like that only, right? So this is the chief policy making body, right? So in practice, the cabinet will exercise all the powers. In theory, that is by constitution, the council of ministers will exercise this power. Okay. So wherever you have read the satisfaction of the president, it is not the satisfaction of the president, it is the satisfaction of the council of ministers headed by prime minister. But in practice, in most cases, the cabinet will decide everything. Okay. So does it mean just the president is the figurehead? That is for the namesake. If it is namesake, then it is called nominal. If it is constitutional, at certain circumstances, he has power. See, our president of India is not nominal or figurehead. Okay, he's a constitutional head. What does it mean is, what is the difference between nominal and constitutional head is, see, normal situation, extraordinary situation. In normal situation, he is like figurehead, that is no power. In extraordinary situation, he has certain powers, means it is constitutional. In both the circumstances, he only remains symbolic, that is figurehead, means that is nominal. Okay, he has no power at all. So our president is the constitutional power. He has certain powers in the extraordinary situation. We will discuss it later. As of now, what you want to understand is, wherever you read the satisfaction of the president, it is not the satisfaction of the president, it is the satisfaction of the council of ministers headed by prime minister. Okay, that is what you have to understand from the point of discussion till now. Okay. So as of now, we have seen the difference between the president and the relation between the president and council of minister. Now we can attend one quiz. Okay, sir.
Yes, sir.
And the first quiz button.
Okay, sir.
Sir.
Yes, sir.
Link update பண்றீங்களா இல்ல கண்டினியூ பண்ணுவாங்க சார்?
Please proceed with the question, sir. I will update the link shortly.
Okay, sir. இல்ல அந்த லிங்கோட சேர்த்து கூட போட்டுருங்க சார். இப்போ கண்டினியூ பண்றதுல அப்படியே.
Okay, sure.
Okay, friends. So, the first statement, the executive power of the Union of India is vested in the Prime Minister. The statement is clearly wrong. We have seen Article 53 states that the executive power of the Union is vested with the President. Okay, so the first statement clearly wrong. So we can eliminate the option. Both 1 and 2 is both 1 and 2 we can eliminate. One only also we can eliminate. So we will remain with 2 option. That is 2 only, neither 1 nor 2. The Prime Minister is the ex officio chairman of the civil services. This is we not studied this one. So, but this statement is also wrong. The cabinet secretary is the ex officio chairman of the civil service board. So both are wrong. Neither 1 nor 2 is the correct answer. Okay. Vested means given. Okay. Given in the given with the or given in the. Okay. So now you have understand the difference between the president and the prime minister. That is who has the real power. Okay. So wherever it is mentioned the satisfaction of the president, and it is the satisfaction of the council of ministers headed by the prime minister. That is what you have to understand. Okay. I don't get your question. Okay. Cabinet secretary directly under your prime minister. Cabinet secretary works for the cabinet. Okay. Okay. I will improve. Is it audible now? So we will deal with the special powers of the president, right? Ordinance making power, pardoning power, veto power, emergency power. These are very important. These are the important powers of the president. We will look at one by one. Okay. So start with emergency power. See, emergency powers are dealt in Part 18 of the Constitution from Article number 350 to 360. Okay. The quiz will be updated soon. So let us kind of watch the session, right? So the emergency powers are codified in the Constitution under Part 18 of the Constitution from Article 352 to 360. There are 3 kinds of emergency: national emergency, state emergency, and financial emergency. But Constitution nowhere uses this kind of words. It only uses the act of proclamation for emergency. But for our convenience, we have classified it into national emergency, state emergency, and financial emergency. Okay. Yeah, prime minister is executive person, but the executive power of the union is vested in the president. He can use this power either directly or indirectly. By virtue of the power indirectly, the prime minister can also use that power. That is what I am explaining the difference in Article 53 and Article 74. Okay. If you have doubt at all, we will discuss it again in the end of the session. Now we will focus on the powers of the emergency powers of the president. It is mentioned in the Part 18 of the Constitution from Article 350 to 360. 3 kinds of emergency are there: national emergency, state emergency, financial emergency. But Constitution did not mention these kinds. It only mentions the act of proclamation of an emergency. Okay. So first we will start with national emergency. National emergency can be declared on 3 grounds: war, external aggression, internal disturbance. This was originally mentioned in the Constitution. But the third emergency that was introduced in the 1975 makes more controversial because it used the clause the internal disturbances. So after the emergency period was over, the 44th Constitutional Amendment Act was enacted. In that, the word internal disturbance was removed from the Constitution. Instead, armed rebellion was inserted. Okay. Now the Constitution reads us the grounds for the national emergency is war, external aggression, armed rebellion. War and external aggression are classified into external emergency. Armed rebellion is classified as internal emergency. Okay. So it is very clear the emergency, national emergency can be classified into 2: external emergency and internal emergency. External emergency criteria, war or external aggression. Okay. Internal emergency means armed rebellion. So this is the ground for declaring national emergency, right? Now there are certain articles related to the national emergency. Article 352. Okay, Article 352 talks about the national emergency. That is, the President of India can declare emergency on the security of India. That is, security of whole of the India is affected, or part of it. Okay, part of the India's security is threatened by war or external aggression or armed rebellion. He can declare the national emergency. That is, whether it is external or internal. If part of the or whole of the security of India is threatened, then the President of India can declare national emergency. That is, if the President of India can declare national emergency means the Council of Ministers headed by Prime Minister advised the President to proclaim the national emergency. So, who proclaimed the national emergency? It is only the President. Whether the President can act on his own wish? No. He can act on the aid and advice of the Council of Ministers headed by Prime Minister. Okay. The national emergency is declared by President, no doubt with that. But he cannot declare on his own will. He can declare only on the advice of the Council of Ministers headed by Prime Minister. Okay, that is what Article 352 said. That is why I have explained you earlier. That is wherever the President, it is not the President, it is the Council of Ministers headed by Prime Minister. Right now, the President can proclaim even before the actual occurrence of the war. That is, the security of India, whole of the security of India, part of it is not threatened till now. Okay, not the war has been occurred. It has been considered in the near future. It will occur. So then also the President can proclaim the emergency. That is, even before actual occurrence of the war, the President can proclaim the national emergency. On the ground, it will happen. Okay. Now, can issue different proclamation without consideration of prior issue. For example, there is already a national emergency. Okay, when 1975 the emergency was declared, there is already there was an emergency and there is a proclamation with regarding to that emergency. Again, they can give different proclamation. Suppose the national emergency was declared, one proclamation was given. Again, the proclamation can be given without considering what has been given in the prior proclamation, right? Proclaim means announcing. Okay, proclaim means announcing. See, proclamation means announcing. Okay, instruction, giving instruction. That is, if the national emergency is proclaimed, that is, national emergency is proclaimed. Okay. No, 42nd Constitutional Amendment Act is done by then Prime Minister Indira Gandhi. 44th Constitutional Amendment was made by the Janata government that returned to the power after emergency. Okay, national emergency. Once the national emergency was declared, first they can give certain set of instructions. The people can't do this, the executive cannot do this like that. Okay, after that they can give again certain instruction which might be contradictory to their prior instruction. Hello. This might be the contradictory to the prior, or it contains something same meaning in the prior instruction. So there is no restriction on giving instruction with reference to the national emergency. That is what the point mentioned. Okay. So national emergency can be for entire country or only a part of it. Okay. It can be applied to the entire country or only a part where it was affected. It was introduced by the, this provision was introduced by 42nd Constitutional Amendment Act. Okay. The state legislature hold power during the national emergency response. We will see that. Okay. President can proclaim national emergency only after receiving written recommendation from the cabinet. Okay. See, this is the only article where the cabinet was used in the constitution. Okay. President can proclaim national emergency only after receiving written recommendation from the cabinet. It was introduced by 44th Constitutional Amendment Act. Okay. Why it was so? I will give you time total. Okay, let us finish this one slide. Okay. So see what happened. The 1975 national emergency. Okay. In 1975, okay, then Prime Minister Indira Gandhi announced. See, in 1975, the Prime Minister is Indira Gandhi. The President is Fakhruddin Ali Muhammad. Okay, what the Prime Minister said is he advised the President to implement the national emergency on the grounds of internal disturbance. At the time, it was the internal disturbance. Okay, the emergency was announced in the midnight. Okay, it was announced in the midnight. See, every decision has to be taken collectively in the parliamentary form of government. But the Prime Minister Indira Gandhi didn't uh, consulted his cabinet or council of ministers. He individually advised the president and he implemented the emergency. So after that, and it will become, this emergency becomes the most controversial one, right? So after the fall of Indira Gandhi and the Janata Party came to the power, they have made number of changes to the 42nd Constitutional Amendment Act that was made during the emergency period. One such changes was the president has the president can implement the national emergency only with the written recommendation of the cabinet. Okay. Written recommendation the prime minister has to given in notice to the president. Okay. So that only it was added. Now you can attend the quiz. After that, we will continue the session. Okay. Okay. So the recommendation does not require majority anything. This one, the majorities are only when the approval of legislature is needed. Okay. So see, don't get confused. Okay. Carefully watch the session. After the session, you can recall this either this PPT or the Lakshmikant book. You will get some additional information in the book. So if at all after you confused, then you can ask. While on the session, don't get to. Okay. get to analyze and get confused. Okay. See, once the cabinet, that is the prime minister, give the written recommendation to the president can approve the national emergency. Okay, but proclamation of national emergency must be approved by both the houses of the parliament within 1 month. That is, the prime minister given written recommendation to the president to approve the national emergency, then he approved it. The national emergency will become active. Okay, but for its continuance, it should be approved by the both houses of the parliament, that is Lok Sabha and Rajya Sabha, right? Within 2 months. In the original constitution, it was the time period given was 2 months, but in the after 44th Constitutional Amendment Act, it was reduced to 1 month. Now it was 1 month. Okay. Before the 44th Amendment Act, it was simple majority. Now it was a special majority after the 44th Constitutional Amendment Act. Why these changes are means that in the 1975, the emergency declared by the then Prime Minister Indira Gandhi was the controversial one. Okay, and that 2-year period is called the darkest period in the democracy of India. Okay, so that number of safeguards have been incorporated in the 44th Amendment Act. Okay, see, once both houses are approved, it can be continued for 6 months. Okay, and can be extended for indefinite period with the periodic approval of parliament. That is, every 6 months once the parliament has to approve the national emergency to continue. By approving it every 6 months, it can continue for indefinite period, and the periodic approval was also inserted by the 44th Constitutional Amendment Act. Before the 44th Constitutional Amendment Act, revocation, that is removal of the national emergency, can be done unilaterally by the president. Okay, that is without considering the legislature, they can remove the national emergency. That was before the 44th Constitutional Amendment Act. But after 44th Constitutional Amendment Act, 1/10 of the Lok Sabha, okay, 1/10 of the Lok Sabha will give a written notice to the speaker. Okay, if the parliament is in session. If so, the parliament is not in session, they can give the written notice to the president. After this notice has been given, a special sitting of house should be held within 14 days of the notice. Okay, held within 14 days of the notice for the purpose of considering a resolution disapproving the national emergency. Okay, disapproval is only by the Lok Sabha and it requires only simple majority. Okay, I am again summarizing for you approval and disapproval. Okay, see, we are seeing national emergency. Okay, we are seeing national emergency. Now we can summarize the approval procedure of national emergency and removal or disapproval procedure. Okay, disapproval procedure. See, the Prime Minister having the notice of written recommendation of the cabinet, then he would give it to the president to proclaim national emergency. Then the president proclaim the national emergency. Now, after the proclamation, this proclamation has to get the approval of the legislature, that is parliament, that have two houses, Lok Sabha and Rajya Sabha. In both the houses, it has to get approval. If one of the houses didn't give approval, the national emergency will not continue. It will end there itself. Okay, the both houses has to given approval to the national emergency. That is both Lok Sabha and Rajya Sabha. What majority? Special majority. Okay, special majority under Article 368, right? Special majority. Before 44th Amendment Act, it was simple majority, right? Once approved, it can be continued for 6 months. But with the every 6 months, the approval, it can be continued for indefinite period. Okay, to disapprove the national emergency, the president can unilaterally revoke the national emergency before 44th Constitutional Amendment Act. But after 44th Constitutional Amendment Act, the 1/10 of the Lok Sabha peoples, okay, 1/10 of the Lok Sabha people has to given the notice to the speaker or president if the session of the parliament is not, okay, either given to the speaker or the president. Okay, 1/10 of the Lok Sabha members has to give the written notice to the speaker, right? After that, within 14 days of the receipt of notice, they have to consider the special session. Okay, special session in the parliament by Lok Sabha. In that, they have to approve the disapproval of national emergency. It requires simple majority, right? Now you have to understand the difference. For disapproval, only simple majority. For approval, it is special majority. For approval, both houses' permission is necessary. For disapproval, only Lok Sabha's permission is enough, right? So these are the difference between the approval and disapproval of national emergency, right? So now we will see the impact of the national emergency. What are the impact it will have? Okay. First, we will start with union executive. See, the power extends to any state on any matter regarding the manner in which the executive power is to be exercised. That is what they are trying to say is, see, union executive, that is president. He will act on the advice of Council of Ministers headed by Prime Minister. Their power will extend to the state, all the state governments. Okay, any state government for any matter. Okay, they will exercise. But the state government is not suspended here, but they also run parallelly. Okay, central government will run parallelly, state government will run parallelly. But if there is any contradiction between the two, then the parliament's law, that is the union, what the union that will be prevailed. Okay. So union executive power all becomes strong and state will go under the union. That is the country's nature federal becomes unitary without an amendment. Okay. Now, what is the impact on the state legislature? The state legislature is not suspended, right? But parliament has the overriding power. It is the same case with respect to the executive. Right? Now, judiciary. Judiciary has been no impact on judiciary except the exception made by Article 358 and 359. That is, if your fundamental rights are violated and if it is available, you can enjoy. If it is not available, you can't ask as the matter of right. Okay. So this is what the effect on the judiciary. Otherwise, there is no effect on judiciary, right? Financial relation. President can modify the distribution of revenue between the center and state while during the national emergency, right? Fundamental rights. The national emergency's effect on fundamental rights. Article 358 mentions it is only applicable for the external emergency, right? Article 19 automatically suspended. When national emergency is proclaimed by the condition of Article 358, Article 19 was automatically suspended. It cannot be suspended by the president. When national emergency, when Article 352 national emergency invoked, Article 19 automatically goes out. There is no remedy for the violation of fundamental rights during national emergency. That is only for Article 19, right? Article 359, okay? It is for both external and internal emergency, but it will not automatically, it has to be done by the presidential order, right? Here, rights are not suspended, but only the enforceability is suspended. Whereas in Article 19, the right itself is suspended, right? So the Article 20 and 21, when the presidential order suspending during national emergency, they can't suspend the rights of Article 20 and 21, okay? So what does it mean is even during the national emergency, Article 20 and 21 are available, right? So, but except 20 and 21, there is no other remedy for the rights suspended, okay? So these are the impacts of national emergency. See, we have seen that what is national emergency, grounds for national emergency, the proclamation procedure, approval and disapproval procedure, effects of national emergency on different heads, okay? Executive, state legislature, fundamental rights, judiciary, financial relation, etc. Now we will start with state emergency. See, state emergency or constitutional emergency or president rule or governor rule. These are the commonly used terms for this kind of emergency. Here also there are 3 articles: Article 355, Article 356, Article 365. Okay, try to understand it. See, there are number of provision given in the Constitution, right? So the Article 355 give the power to the central government, right? Give the power to the central government to watch the state government whether they are following the constitutional provision or not. That is, The Article 355 put the obligation on the central government to ensure that state governments are carrying their administration in accordance with the provisions of the Constitution. Okay. Article 365 said that if suppose the state government fails to carry out the administration in accordance with the provision of the Constitution, then they can implement that is the central government can implement the Article 356, that is the proclamation of the state emergency, right? So 355 makes obligation on the center, and using this 355, if the center is watching, then the state, if failed to the 355, then the central government can implement the 356. Okay. There are other articles, some related to this are 256 and 257. These are specific directives given by the center to the state governments. Even if these directions are missed by the state, then also they can implement the Article 356, right? So 352 national emergency, 356 state emergency. See here, Article 356 empower the president to issue a proclamation if he is satisfied that a situation has arisen in which the government of a state cannot be carried out in accordance with the provisions of the Constitution, right? So 355 is the obligation. 365 is where the state has failed the obligation, right? So the central government can use the Article 356 to issue the state proclamation, right? State emergency. See. Article 355 talks about the Article 355 confers power on the central government. 385 என்ன சொல்லுதுன்னா சென்ட்ரல் கவர்மெண்ட்டுக்கு பவர் கொடுக்குறாங்க. ஸ்டேட் கவர்மெண்ட் எல்லாம் வாட்ச் பண்ணணும், ஓகேங்களா? அவங்க வந்துட்டு கான்ஸ்டியூஷன் ப்ரொவிஷன் படி கரெக்டா ஃபாலோ பண்றாங்களா இல்லையா அப்படின்றத வாட்ச் பண்ணணும். அந்த பவர் யாருக்கு கொடுக்குறாங்க? சென்ட்ரல் கவர்மெண்ட்டுக்கு கொடுக்குறாங்க. இப்போ 365 என்ன சொல்றாங்கன்னா ஸ்டேட் கவர்மெண்ட் அதை ஃபாலோ பண்ணல, கான்ஸ்டியூஷனல் ப்ரொவிஷன் படி போகல, ஏதோ ஒரு சில தப்புகளை பண்ணிட்டாங்க, ஓகேங்களா? அப்ப சென்ட்ரல் கவர்மெண்ட் என்ன பண்ணலாம்னா 386 யூஸ் பண்ணி அந்த ஸ்டேட் கவர்மெண்ட்டை அந்த ஸ்டேட்ல வந்துட்டு ஸ்டேட் எமர்ஜென்சி கொண்டு வரலாம், ஓகேங்களா? அதாவது பிரசிடென்ட் ரூல்ல வந்துட்டு அமல்படுத்தலாம், கரெக்டுங்களா? இது 355 365 சொல்லிட்டு 256 257 என்ன சொல்றாங்கன்னா இதெல்லாம் ஸ்பெசிபிக் அட்மினிஸ்ட்ரேஷன். ரயில்வே இந்த 256 என்ன சொல்றாங்கன்னா மீன்ஸ் ஆஃப் கம்யூனிகேஷன் வந்து எப்படி ப்ரொடெக்ட் பண்ணணும்னு சொல்றாங்க. ரயில்வேஸ், ரோட்வேஸ், ஹைவேஸ், வாட்டர்வேஸ், ஏர்வேஸ் இதெல்லாம் எப்படி ப்ரொடெக்ட் பண்ணணும்னு சொல்றாங்க. இப்போ இதுல கொடுக்குற இன்ஸ்ட்ரக்ஷன் அவங்க ஃபாலோ பண்ணலன்னா கூட இந்த 356 இம்ப்ளிமெண்ட் பண்றதுக்கு வாய்ப்பு இருக்கு, கரெக்டுங்களா? அதனாலதான் ஏதாவது ஒரு ஸ்ட்ரைக்னா என்ன பண்ணுவாங்க, நேரா போய் ட்ரெயின் முன்னாடி உட்காந்துருவாங்க. ஏன்னா அது வந்து இந்த மீன்ஸ் ஆஃப் கம்யூனிகேஷனுக்குள்ள வருது. இப்போ அதை வந்து கட்டாயில் பண்ணிட்டாங்க அப்படின்னா வந்துட்டு அந்த கவர்மெண்ட்டே வந்துட்டு டிசால்வ் பண்ணலாம் இல்லையா? ஸோ அதனாலதான் எல்லாத்துக்கும் உடனே என்ன பண்றாங்க, ட்ரெயின் முன்னாடி போய் போராட்டத்தை பண்றாங்க, கரெக்டுங்களா? ஸோ இதுதான் இந்த இதுல சொல்லியிருக்காங்க 355 365 356. இது வந்துட்டு ஸ்பெசிபிக் டைரக்ஷன்ஸ் கிவன் பை த ஸ்டேட். இதுல சொல்றது வந்துட்டு ஜெனரல் டைரக்ஷன்ஸ், ஓகேங்களா? So, reason for invoking Article 356. Constitution. What Constitution says is only for the failure of constitutional machinery. But Constitution does not define what constitutes the failure of constitutional machinery. So it was referred by various cases by the Supreme Court. Okay. The political crisis, breakdown of administration, internal subversion by the state. Political crisis means no party gets the clear majority, right? In that case, if no party has the chance to form the government, then it is called the failure of constitutional machinery. Breakdown of administration is of two types, right? One is man-made crisis, another one is natural disaster. The communication lines, the entire state becomes physically breakdown, then it can be declared as the failure of constitutional machinery. That is, it is beyond the scope of state government to clear that, right? In that case, it can be called as failure of constitutional machinery. Internal subversion by the state means the state goes against the constitution. That is, it can go against the Supreme Court or High Court's order, or it can openly defend the constitution. That is, it can openly against the constitution. That is called internal subversion by the state. So these are considered as the ground that is considered as failure of the constitutional machinery. By the failure of machinery, the central government can invoke the Article 356, right? Now, see, the while invoking Article 356, okay, I will go slow. I will again explain you. See, what Constitution tell us is the state emergency can be only implemented for the failure of constitutional machinery, but the Constitution does not define what constitutes failure of constitutional machinery. Okay, so by various cases, the Supreme Court has evolved that these are the failure of constitutional machinery. The first one is political crisis. Political crisis means if the no party gets clear majority, okay, if the no party gets clear majority to form the government, then it is called political crisis. Then the political crisis come under the failure of constitutional machinery, right? So in that category, the central government can implement Article 356. Okay? This is the first point. Second point, breakdown of administration. Breakdown of administration means physically, that is the it is of two types. One is natural disaster, another one is any man-made crisis or disaster, right? If the state's communication lines are physically broken down, okay, the capacity of the state is not enough to recourse to the normal administration, then it is considered as the failure of constitutional machinery. Then the central government can implement the Article 356, right? This is the second. Third one is internal subversion by state. What does it? It also has two. One, going against the order of the High Court or Supreme Court. Okay, that is going against the order of the courts. That is not following the orders given by the courts. Then open defiance to the Constitution. That is what the state doing is against the Constitution. Okay. Then these are considered as the case of failure of constitutional machinery. Okay. In that condition, the central government can advise the president to declare the state emergency in the particular state. Right? There are many examples. Okay. All the political crises we have seen. The classic example is Delhi. Until 1 year, the governor has waited for that, but since the government is not able to form, so they have announced the fresh election. Right? There are many examples. The internal subversion, the Manipur case, the recent many cases. The role of governor is very important. In the Tamil Nadu also, when the former Chief Minister Jayalalitha was died, there are many subversions, but the role played by the governor is very essential during this time, right? That we will see in the governor's role. Okay. Now, so while invoking Article 356, there are two things. One, the satisfaction of the president. That is, the president is satisfied. That is what the satisfaction means. The satisfaction of the Council of Ministers headed by the Prime Minister. They can satisfy on their own to invoke the Article 356. One. Second one is the governor can send the report that the constitutional machinery in the state has failure. Then you can approve the state emergency. Okay. On this two ground, the president can declare the state emergency. But Article 74 plus 2, advice tendered by the minister to the president shall not be inquired into any court. That is, Council of Ministers headed by Prime Minister advise the president to declare the emergency. But this advice should not be inquired into the court of law. So what does it mean is, declaring emergency is beyond the judicial review of the courts. Okay. And the 38th Amendment Act of 1975 made the satisfaction of the president. It was in the original constitution itself. Okay. 38th Amendment Act, what made is the advice given is final and conclusive, which cannot be challenged in any court on any ground. Okay. It was made in the 38th Amendment Act, but it was deleted in the 44th Amendment Act 1978. made that satisfaction of the president is not beyond the judicial review. That is, it is subject to judicial review. And court also has mentioned in number of cases that it is subject to judicial review on certain conditions. Okay, that we will see in the coming part of the slides. Now the parliamentary approval and disapproval. Okay, for the state emergency, a proclamation imposing president rule must be approved by both the houses of the parliament within 2 months from the date of issue. See, here it was not modified using 44th Amendment Act. Okay, in the national emergency also it was initially 2 months, but after 44th Constitutional Amendment Act it was 1 month. But for the state emergency, they didn't change anything. It is only 2 months only. Okay. The proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided that the Rajya Sabha approve it in the meantime. What does they mean through this line is, see, Parliament has two houses, you know, Lok Sabha and Rajya Sabha. It's the permanent house that you know, right? Now they are implementing state emergency. Okay. For example, today, 21st July 2020, they wanted to implement the state emergency, for example, in Tamil Nadu. Okay, but what happened is 30th July 2020, the Lok Sabha dissolved due to some reasons. Okay. Now what happened is the Lok Sabha and Rajya Sabha has to approve within 2 months, right? Then only this emergency will be valid. Otherwise, this emergency is not valid, right? So, how long it will survive? Since there is no Lok Sabha in the, there is no, since the Lok Sabha is dissolved, there is no one to approve this, correct? So, how long it will survive means once again the Lok Sabha is constituted, from the date of constitution until the 30th day, the emergency will be valid. Suppose we will take that on the 1st August, we will consider two cases. One, the 1st August 2020, the new Lok Sabha has been considered. The other case is, okay, August, September, the January, okay, only the 21st January, okay, 20 January 2021. In this case means from this 30 days, okay, both cases are valid. That is only when the date of Lok Sabha is reconstituted from that 30 days. Okay. So this is what the line tries to explain. Right? If before approving the state emergency, the Lok Sabha dissolved, then the emergency will be valid after reconstituting Lok Sabha and then from 30 days. Okay. Now, if approved, okay, once it was approved by both houses of the parliament, the president rule continues for 6 months. Okay, it can be extended for a maximum period of 3 years. See, state emergency was imposed. Okay, for example, 21st July 2020, the state emergency was imposed. Within 2 months, it has to be approved by both Lok Sabha and Rajya Sabha, correct? Within 2 months, it has to be approved by both Lok Sabha and Rajya Sabha. But in the meantime, that is within the 2 months, the Lok Sabha has been dissolved. Okay, Lok Sabha has been dissolved for some reasons. Okay, now it is not able to approve that. Okay, so then how long this emergency imposed will be valid? That is, see, 21st July, the state emergency was imposed. Consider in 21st August 2020, the Lok Sabha dissolved. Okay, Lok Sabha get dissolved. Okay, so how long it is valid? Correct. So since the Lok Sabha is reconstituted, since the Lok Sabha is again reconstituted, and from the date of reconstitution to 30 days, it is valid. That is what the point try to explain. சிம்பிளா சொல்லணும்னா இப்போ இன்னைக்கு வந்துட்டு நேஷனல் ஸ்டேட் எமர்ஜென்சி இம்போஸ் பண்றாங்கன்னு வச்சுக்கோங்க. 20 ஜூலை 2020 இம்ப்ளிமெண்ட் பண்றாங்க. ஓகேங்களா? இதுல இருந்து 2 மாசத்துக்குள்ளார லோக்சபா ராஜ்யசபா ரெண்டுமே வந்துட்டு அப்ரூவல் கொடுக்கணும். ஆனா இந்த 2 மாசத்துக்கு கொடுக்கறதுக்குள்ளார என்ன ஆயிடுது, லோக்சபா வந்துட்டு ஏதோ ஒரு காரணத்துக்காக, ஓகேங்களா, அது அப்ப இந்த இம்போஸ் பண்ண ஸ்டேட் எமர்ஜென்சி எவ்வளவு நாளைக்கு வேலிடா இருக்கும் அப்படின்னா, இந்த கலைஞ்ச லோக்சபாவை திரும்ப ரீகான்ஸ்டியூட் பண்றதுக்கு, கான்ஸ்டியூட் பண்ற வரைக்கும், பிளஸ் கான்ஸ்டியூட் பண்ணதுக்கு அப்புறம் அதுல இருந்து 30 நாள் வரைக்கும் வேலிட். ஆனா இந்த மீன் டைம் ராஜ்யசபா வந்து அப்ரூவல் பண்ணிக்கிட்டே இருக்கும் எவ்ரி 6 months ஒன்ஸ். ஓகேங்களா? ஸோ அப்படி பண்ணிட்டு இருந்தா இட் இஸ் வேலிட். கிளியர்? ஓகே, ஒன்ஸ் 2 ஹவுஸ் மூலமாவும் அப்ரூவ் பண்ணிட்டாங்க அப்படின்னா பிரசிடென்ட் ரூல் 6 மாசத்துக்கு கண்டினியூ. ஓகே, the president rule will continue for 6 months. It can be extended for a maximum period of 3 years. What does it mean is, in the state you cannot continuously extend the president rule beyond 3 years, whereas in the national emergency there is no time limit, correct? Then the approval of the parliament with every 6 months, correct? So the proclamation surveys, okay, it was already discussed, right? Now, restraint on the power of the to proclaim a president rule beyond 1 year. Center only implement. Okay, center only implement. That is what I have explained in the first slide. So article 355, 356, 365, right? Center only implement, state will not implement. Okay. So restraint on the power, okay, restraint on the power of the proclamation of president rule beyond 1 year. That is, if you want to continue the president rule in the state more than 1 year, means it has to satisfy 2 conditions, and that condition was inserted by the 44th Amendment Act of 1978. The first condition is the proclamation of national emergency should be in operation in the whole of India or in any part of the state. Okay, that is, if you want to extend the state emergency in any state beyond 1 year, means at the time there should be any national emergency should be in operation, then you can extend more than 1 year. Otherwise, the election commission must certify that the general election to the assembly of the concerned state cannot be held on account of difficulties. Okay, if the 2 conditions or any one of the condition has been satisfied, then only you can extend more than 1 year of any state. Okay, otherwise you can't extend that. Right? Now, with respect to approval, so state emergency requires only simple majority, whereas national emergency requires special majority. It can be revoked by the president at any time. It does not need any parliamentary approval, whereas in the national emergency it requires the simple majority of Lok Sabha. Correct? See, the condition என்னன்னாங்க very simple. ஓகேங்களா? ஃபர்ஸ்ட் என்ன சொல்றாங்க அப்படின்னா, நீங்க ஒரு ஸ்டேட் எமர்ஜென்சி, ஒரு தமிழ்நாட்டில் ஸ்டேட் எமர்ஜென்சி போடுறாங்கன்னு வச்சுக்கோங்களேன், 1 வருஷம் ஆயிடுச்சு. ஓகேங்களா? இப்போ என்ன பண்றாங்க, திரும்பவும் இன்னொரு 6 மாசத்துக்கு எக்ஸ்டெண்ட் பண்ணணும் அப்படின்றாங்கன்னா, அப்போ வந்து 2 கண்டிஷன் சாட்டிஸ்ஃபை ஆனா மட்டும்தான் எக்ஸ்டெண்ட் பண்ண முடியும். இந்தியாவில் நேஷனல் எமர்ஜென்சி டிக்ளேர் வந்து ஃபோர்ஸ்ல இருக்கணும். அப்போ 1 வருஷத்துக்கு மேல நீங்க ஒரு ஸ்டேட்ல பண்றீங்கன்னா, நேஷனல் எமர்ஜென்சி ஃபுல் இந்தியாவுக்கும் இல்லை ஏதோ ஒரு பார்ட்ல நேஷனல் எமர்ஜென்சி ஆப்ரேஷன்ல இருக்கணும். அப்படி இருந்தால் தான் நீங்க ஒரு ஸ்டேட்டை மோர் தென் 1 இயர் வந்துட்டு ஸ்டேட் எமர்ஜென்சியில கொண்டு போக முடியும், இல்லைன்னா கொண்டு போக முடியாது. 2வது கண்டிஷன், எலெக்ஷன் கமிஷன் வந்து சர்டிஃபை பண்ணணும். இந்த ஸ்டேட்ல வந்து இப்போதைக்கு தேர்தல் நடத்துறதுக்கு முடியாது, நிறைய டிஃபிகல்டிஸ் இருக்கு அப்படின்னு சொன்னாங்கன்னா 1 இயருக்கு மேல எக்ஸ்டெண்ட் பண்ணலாம். இந்த 2 கண்டிஷன் இல்ல 2ல ஏதாவது ஒரு கண்டிஷன் சாட்டிஸ்ஃபை ஆனா மட்டும்தான் ஒரு ஸ்டேட்டை வந்துட்டு 1 வருஷத்துக்கு மேல அதை எமர்ஜென்சி பீரியட்லயே வச்சிருக்க முடியும், இல்லைன்னா அந்த மாதிரி வச்சிருக்க முடியாது. ஓகேங்களா? ஆர்டிகல் 356 அப்படின்றத எப்படி பார்த்தாங்க அப்படின்னா, கான்ஸ்டிடியூஷனல் மேக்கர்ஸ் ஃபோர் ஃபாதர்ஸ் வந்துட்டு இதை வந்து ஒரு டெட் லெட்டரா தான் பார்த்தாங்க. அதாவது இந்த மாதிரி ஒரு பவர் இருக்கும், இதை வந்து யூஸே பண்ண மாட்டோம் அப்படின்னு பார்த்தாங்க. ஓகே, the constitutional makers seen article 356 as a dead letter, but what what in reality is, it becomes the deadly weapon. Okay, because it was used more than the times, right? It was used for to settle the political scores also. Okay, after the emergency, the Janata Party came to the power. It has removed all the state legislative assembly that Congress ruled, that it is now against the wishes of the people. The same was done by the Congress when it came to the power. Okay, this kind of many things happened using this Article 356, right? Yes, it can be extended up to 3 years, this one, but the condition it has to satisfy. That is maximum. Okay, the maximum is 3 years. Okay. Yes, the state during state emergency, the state assembly will be dissolved. Okay, but as of now, it is not the condition. As of now, see, when the state emergency is imposed, when the state emergency is imposed, it has two conditions. One, dissolve. Another condition, suspend. Okay. Now, it was the earlier case. Now, you have to suspend. You should not dissolve directly. First, you have to suspend. Only after the approval of the parliament, you can dissolve. Suppose if it is related to the forming of government, right? I've seen the failure of constitutional machinery under three head. One head is with respect to the hung assembly, right? Then the then the center can wait to form the government without the fresh election. If it is not possible, then they can dissolve the state assembly. Then they conduct the fresh election. Okay. No, it has to be conducted within 6 months from the revocation of the emergency. Okay. Now, so this deadly letter become deadly weapon. So there are checks and balance has been ensured to the Article 356. There are different kinds of checks and balance. One is judicial verdict, presidential notings, the commissions, recommendations, Sarkaria Commission, Panchi Commission reports. Right? The famous case is SR Bombay case. Okay, what happened in this case is he was an SR Bombay was an chief minister of Karnataka. Okay, but for some part of certain MLAs has been claimed that they have the majority, so they approached the governor of the sea. They defected from the party and they approached the governor of Karnataka that they claim that they have the majority. So the governor of Karnataka what done is they dissolved the chief ministers. They dissolved the Bomoi's rule and they called them to the floor of testing. But he approached the Karnataka High Court. The petition was dismissed in the High Court, and so he approached the Supreme Court. Okay, this was happened in '89, but the verdict came only at the 1994. But the verdict has changed the nature of Article 356. Right now, we will see the verdicts what has been held in that case. Right. So these are the verdicts given in the Omai case. Okay. The presidential proclamation imposing president rule is subject to judicial review. First point, it is the imposition of the emergency in the state is subject to judicial review. First, the satisfaction of the president must be based on the relevant material. That is, the satisfaction of the president. That is, the satisfaction of the Council of Ministers headed by Prime Minister should be based on the material, not on the personal whims. Okay. That is, if the Council of Ministers feels that the state is chaotic, then it is not. Okay, he has to produce it by the relevant facts and the material. Okay, so it should be based on the relevant material. The action of the president can be struck down by the court if it is based on irrelevant or extraneous, or it was found to be nullified or to see. These all the words are similar meanings. Don't get confused by this word. What the court said is what the material produced by the center is wholly wrong or not relevant, then the court can strike down the implementation of the state emergency done by the president. Okay. Now, the burden lies on the center to prove that relevant material exists to justify the imposition of the president. That is, for example, if the central government implement the state emergency in Tamil Nadu, okay, for example, okay, now the Tamil Nadu government approached the Supreme Court. Now, the relevant material is the center has to prove that there is the situation is relevant to the implementation of the state emergency. That is, the burden of proof is given on us on the center, not the state government. Okay, those who approach the not to produce. Okay, I will explain it in Tamil also. Don't worry. See, very simple. SR பொம்மைன்றவர் கர்நாடகாவோட சீஃப் மினிஸ்டர் வந்திருக்காரு. அப்ப என்ன ஆகுது அப்படின்னா, ஒரு 19 எம்எல்ஏ வந்துட்டு அவங்க பார்ட்டில இருந்து வெளில போயிட்டு எங்களுக்கு வந்துட்டு பவர் இருக்குது, எங்களுக்கு வந்துட்டு சப்போர்ட் இருக்கு அப்படின்னு சொல்றாரு. ஆனா இவருக்கு சஃபிஷியன்டா மெஜாரிட்டி இருந்திருக்குது. பட் இருந்தும் அந்த மாதிரி கவர்னர்கிட்ட சொல்லியிருக்காங்க. கவர்னர் வந்துட்டு வேற பார்ட்டி அலிஜியன்ஸ் இருந்ததுனால என்ன பண்றாரு, இந்த பொம்மாயியோடைய இதை வந்துட்டு ஆட்சி கலைச்சிட்டு அவங்க இவருக்கு மெஜாரிட்டி இல்லைன்னு சொல்லி கலைச்சிட்டாங்க. ஆனா அவர் வந்துட்டு நான் மெஜாரிட்டியை ப்ரூஃப் பண்றேன், எனக்கு ஒரு வாய்ப்பு கொடுக்குன்னு கேட்டாரு. அந்த வாய்ப்பையும் கொடுக்காமலே வந்துட்டு கலைச்சிட்டாங்க. ஓகேங்களா, மெஜாரிட்டி இல்லைன்னு. அவர் ஹைகோர்ட், கர்நாடகா ஹைகோர்ட்டுக்கு போறாரு. அந்த ஹைகோர்ட்ல டிஸ்மிஸ் பண்ணிடுறாங்க பெட்டிஷனை. அதனால சுப்ரீம் கோர்ட்டுக்கு போறாங்க. சுப்ரீம் கோர்ட் என்ன பண்றாங்க, பிரசிடென்ட் பண்ணது தப்பு அப்படின்னு சொல்லிட்டாங்க. அது இல்லாம வந்து பாத்தீங்கன்னா நிறைய கைட்லைன்ஸ் வந்துட்டு கொடுத்துருக்காங்க. அது என்னென்ன கைட்லைன்ஸ் அப்படின்னு பாத்தீங்கன்னா, பிரசிடென்ட் ரூல் வந்து இம்ப்ளிமெண்ட் பண்றது ஜுடிஷியல் ரிவ்யூக்கு உட்பட்டது அப்படின்றதுதான் ஃபர்ஸ்ட் பாயிண்ட். ஏன்னா நம்ம ஆர்டிகல் 74 கிளாஸ் 2ல பார்த்திருக்கோம், அந்த அட்வைஸ் வந்துட்டு கோர்ட் எந்த கொஸ்டின் கேட்கக்கூடாதுன்னு சொல்லியிருப்பாங்க. இதுக்கு கோர்ட் என்ன பதில் சொல்லியிருப்பாங்க அப்படின்னா, நாங்க வந்து அந்த அட்வைஸை தான் கொஸ்டின் பண்ணக்கூடாது, அந்த அட்வைஸ் எந்த மெட்டீரியல் பேசிஸ்ல பண்ணீங்கன்றத நாங்க கொஸ்டின் அப்படின்ட்டு ரிலவெண்ட் மெட்டீரியல் பேசிஸ்ல இருக்கும். ரெண்டாவது பாயிண்ட் என்ன சொல்றாங்கன்னா, the decision taken வந்துட்டு based on the material facts இருக்கணும். நீங்க வந்துட்டு நீங்க ஒரு பார்ட்டி அப்படின்றதுனால நீங்க ஃபீல் பண்றீங்க அப்படின்றதுக்காகலாம் வந்துட்டு அட்மினிஸ்ட்ரேஷன் சரியில்லை அப்படின்னு ஃபீல் பண்றீங்க. இட் ஷுட் பி எஸ்டாப்ளிஷ்ட் பேஸ்ட் ஆன் த எவிடன்ஸ். ஓகே, that should be a backed, the decision should be backed by the material evidence, right? So இப்போ ஹோல்லி ராங்கா இருக்கு அப்படின்னா வந்துட்டு the action of the president வந்து ஸ்டெப் டவுன் பண்ணலாம். கோர்ட்டுக்கு அந்த அதிகாரம் இருக்கு. ஓகேங்களா, செல்லாது அப்படின்னு சொல்ற அதிகாரம் கோர்ட்டுக்கு இருக்குன்னு சொல்றாங்க. அதே மாதிரி இப்போ சென்ட்ரல் கவர்மெண்ட் ஸ்டேட் கவர்மெண்ட் மேல எமர்ஜென்சியை இம்ப்ளிமெண்ட் பண்றாங்க அப்படின்னா, அந்த ஸ்டேட் கவர்மெண்ட்டோ இல்லை வேற யாரோ வந்துட்டு கோர்ட்டுக்கு அப்ரோச் பண்றாங்க, இது வந்துட்டு ராங், இந்த எமர்ஜென்சி இம்ப்ளிமெண்டேஷன் பண்ணது ராங் அப்படின்றாங்கன்னா, இது கரெக்ட் தான் அப்படின்னு ப்ரூஃப் பண்ற பர்டன் யாருக்கு இருக்குது, சென்டருக்கு தான் இருக்குது. யார் கோர்ட்ல கேஸ் போடுறாங்களோ அவங்களுக்கு கிடையாது. இது தப்பா போட்டிருக்காங்கன்னு ப்ரூஃப் பண்ண வேண்டிய கட்டாயம் அவங்களுக்கு கிடையாது. அது கரெக்டா தான் போட்டிருக்குன்னு ப்ரூஃப் பண்ண வேண்டிய கட்டாயம் யாருக்கு இருக்கு, சென்ட்ரல் கவர்மெண்ட். ஓகேங்களா, ஸோ பர்டன் இஸ் லைஸ் ஆன் த சென்டர் டு ப்ரூவ் த மெட்டீரியல் எக்ஸிஸ்ட், ரைட்? அடுத்தது, the court holds the presidential proclamation to be unconstitutional and invalid, it has power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. That is, the president has either dissolved or suspended the state legislative assembly, but it is found that it is invalid or unconstitutional. Then the court can revive the state legislative assembly and set the dismissed government again to the power. This power has the court has this power. It was held in the Bombay case. The state legislative assembly should be dissolved. Okay, it should be dissolved only after Parliament has approved the proclamation. Okay, you cannot dissolve the state legislative assembly only after the proclamation of the state emergency. Until the Parliament given approval, you should not dissolve the state assembly. You can only suspend the state assembly. Until such approval is given, the president can only suspend the assembly, not dissolve. Okay? In case the Parliament fails to approve the proclamation, the assembly would get reactivated. Okay? What is the difference between suspension and dissolve? Suspension means temporary. Dissolve means permanent. Okay? If once dissolved, it has to be again constituted by fresh election. But if the dissolving is wholly wrong, then the Supreme Court can revive the state assembly without fresh election. Okay? So the question of the state government losing the confidence of legislative assembly should be decided on the floor of the house. Until that is done, the ministry should not be unseated. See, what they are telling is, if any state government, if there is a claim that if any state government loses its majority in the house, okay, that whether they hold the majority or not has to be proved in the floor of the house, not in the court of law. Okay, that is, the president cannot dissolve the government until the majority is proved in the house of the floor of the house. See, we can take the example of Tamil Nadu also. After the death of the former chief minister Jayalalitha, what happened was there are many defections, right? So, but the government has not been dissolved, right? Only it has to be tested on the floor of the house. If the government is not survived the test in the floor of the house, then it can be dissolved. Okay. ஸோ சிம்பிளா என்ன சொல்றாங்க அப்படின்னா, ஒரு கவர்மெண்ட்டுக்கு மெஜாரிட்டி இல்லை அப்படின்னு சொல்றாங்க அப்படின்னா, அதை வந்து எங்க தான் முடிவு பண்ணணும்? அசம்பிளியில தான் முடிவு பண்ணணும். ஃப்ளோர் ஆஃப் த ஹவுஸ்ல தான் வந்துட்டு நீங்க முடிவு பண்ணணும். ஓகேங்களா? அது வரைக்கும் அதை முடிவு பண்ற வரைக்கும் பிரசிடென்ட் வந்துட்டு ஸ்டேட் எமர்ஜென்சியை இம்ப்ளிமெண்ட் பண்ணி ஸ்டேட் லெஜிஸ்லேட்டிவ் அசம்பிளியை டிசால்வ் பண்ண கூடாது அப்படின்றது தான் இந்த பாயிண்ட். ஓகேங்களா? ஸோ when a new political party assumes power at the center, it will not have the authority to dismiss the ministries formed by other parties in the state. Suppose, for example, it was happened during the period of 1977 and 1980s, right? But now it is not the case. What happened was, when the Janata Party came to power, it dismissed all the states that Congress ruled. And again, when the Congress party came to power, it dismissed all the states ruled by the non-Congress. So this was the case, but it is not no more. Okay. Now, that is all about the Bommai case. Now we will discuss with respect to the Sarkare Commission. But the Bommai case was based on the recommendations of Sarkare Commission, right? So what it has said is, governor report. Okay, that is, the governor report to the president should be a detailed document. Okay, first of all, it should not be merely the assumption, based on assumption. It should not be based on assumption, it should be a detailed report. State legislative assembly should not be dissolved till the ratification by the parliament. 356 is necessary evil and should be the last resort. That is, this commission did not recommend to abolish the Article 356. It is necessary because India is still nation in making. There are a lot of divisive forces. So it is a necessary evil according to Sarkare Commission, and it should not be used frequently. It should be the last resort. When all other opportunities are exhausted, then only you can use the Article 356. Okay. The Panchi Commission report talks about the localized emergency. Localized emergency means if there is a problem in the state, okay, administration means you can only implement the state emergency to the particular affected area. You don't dissolve the entire state. Okay, that is called the localized emergency. Notings of the president K.R. Narayanan, when he was president, he has finded something. See, when it was implemented, it is with respect to the state of Bihar. Okay, evidence of the breakdown is not established. First of all, the second point he has made is the state legislative assembly enjoys majority that cannot be set aside. When the government is enjoying majority, how could you dissolve? Okay, he asked the second question to the Council of Ministers at that time. Okay, alternate improvements like warning has not been used. That is, you are using the 356 directly. Similarly, placed states are not being brought under 356. What the condition you have said in Bihar is existing in different parts of the country, but why don't you place those states under Article 356? Okay. So these are the notings done by the President K.R. Narayanan. So now, impact of the presidential rule. We have seen the impact of national emergency, right? So now it is the impact of the presidential rule. Executive power of the state loses its identity. Okay. All the powers goes to the union cabinet. The state legislature is either suspended or dissolved. Okay, but the president rule has no effect on the fundamental rights, no effect on judiciary. Only the state executive power and state legislative power got marginalized, right? The second is referring to the presidential. Sir, hello, sir. Sir,
Yes, sir.
second quiz portal.
Okay, sir.
Sir,
Yes, sir.
continue the answer.
Yeah, you can start the session.
So, the President of India exercise his power as provided under Article 356 of the Constitution in respect of a particular state, then what will happen? Okay. The assembly of the state is automatically dissolved. We have seen that it is not the case. Only after the approval of the parliament, only it can be dissolved. So the option 1 is wrong. Okay. Article 19 is suspended in the state. No, it is not. No effect on fundamental right. The president can make laws relating to that state, and the power of the legislature of that state shall be exercisable by or under the authority of the parliament. See, it is more confusing, correct? Because the options are closely placed. The president cannot make laws. Okay, first of all. Okay. Only the power of the state legislature of that state shall be exercisable by or under the authority of the parliament. President can direct the executives, but he cannot make laws. Okay, only the parliament has the authority to make laws. The correct option is option B. Okay. Now, which of the following are not necessarily the consequence of the proclamation of the president rule in the state? That is, it asks about the failure of the constitutional machinery. That is, what are the grounds for the failure of constitutional machinery, correct? So, dissolution of the state legislative assembly. Right? Second one is the removal of council of ministers in the state. Dissolution of the local bodies. See, it is not the case. Dissolution of local bodies. So, if you remove all the threes, it is only 1 and 2, it is correct. When the state legislative assembly lost its majority, so it has to be recalled, it requires the president rule. Okay, removal of the council of ministers in the state. That is, if the council of ministers are removed, then also it will create the vacuum so that the president rule might be the cause. Now we will start with financial emergency. Okay, so the financial emergency was given under Article 360. It empowers the president to proclaim a financial emergency if he is satisfied that a situation has arisen due to which the financial stability or the financial credit of India or its any part of India is threatened. Okay, that is either the whole India or its part is threatened by the financial credit or financial stability, then the president can implement the financial emergency. In 1991, India faced the financial crisis, right? But it does not implement any financial emergency. So, till now, there is no financial emergency has been declared in India. Okay. See, again, the satisfaction of the president was made beyond the scope of judicial review by the 38th Amendment, and it was deleted by the 44th Amendment Act of 1978. So, the proclamation declaring the financial emergency must be approved by both the houses of parliament within 2 months from the date of its issue. Okay. So, it is also not amended by the 42nd Amendment. That is, it has given the time limit of 2 months. The proclamation, this is the same that I have explained in the presidential emergency, right? If the Lok Sabha has been dissolved before approval of the financial emergency, then it will survive until the 30 days from the reconstitution of the Lok Sabha. That is, the Lok Sabha dissolved, again, again the Lok Sabha has been reconstituted. After that, 30 days time will be given. And till that time, the financial emergency will survive, provided if the Rajya Sabha has been approved the ban. Okay. Once it was approved by both the government, once it was approved by both the houses of the parliament, it continues indefinitely. Okay, it is indefinite. No periodical approval is required. Okay, no parliamentary repeated parliament or no periodical approval is required for the continuation of the financial emergency. There is no maximum period prescribed for its operation. Okay, so once financial emergency declared, it will continue until revocation. Okay. So only simple majority is for the approval of the financial emergency. It is revoked by the president at any time. No parliamentary disapproval is required. Right. So effect. If we see the effect of the financial emergency, the executive authority of the center extends to direct any state to observe such canons of financial property as a specified way. See, suppose any financial threat has been happened, then the center give direction to the state. Okay. follow this financial principle, and that is then the state has to be abide by that principle. That is what this point explains. That includes what? Okay, it includes the reduction of salaries and allowance, reservation of all money bills of financial bills of the state to the president. Okay, so these are the meaning that has been implied in this point. Okay, so this is all about the financial emergency. So the ground for the implementation of the financial emergency is only two. Either the whole of India or part of India was threatened by the financial stability or the credit of the country. Okay, so that's all about the financial emergency. Now we will talk about the veto power of the president. Okay, Indian president has three different kinds of veto powers: suspensive veto, absolute veto, packet veto, and veto over state legislation. Let us discuss one by one. Okay, see, first of all, if any bill has to become an act, okay, bill masoda act na sattam. Okay, if any bill wants to become an act, it has to pass by both houses, Lok Sabha and Rajya Sabha, and it has to get the signature of the president. Then it is called an act. Okay, if the president did not give his consent, that is, he did not sign, means then it is called veto. Okay, if he object to sign the bill, then it is called veto of the president. No, it is not financial emergency. Uh, if it that kind of advice will be given if the financial emergency has been implemented. Okay, but no financial emergency has been implemented. Okay, see, first of all, you have to understand the nature of veto. This is very important. Absolute veto was the concept practiced in England, and it is used in private member bills in India. Okay, first of all, absolute veto means what? Veto means withholding the assent. Okay, I have told you already. See, if a bill wants to become an act, it has to pass in both houses, Lok Sabha and Rajya Sabha. After that, president has to give the signature. But if the president refuses to give the signature, then it is called a veto. அதாவது என்னன்னா ரெண்டு ஹவுஸ்லயும் முதல்ல பில் மசோதா வந்து பாஸ் ஆகணும்னா ரெண்டு ஹவுஸ்லயும் ஓட்டு போட்டு தேர்ந்தெடுக்கணும். ஓட்டு போட்டு தேர்ந்தெடுத்ததுக்கு அப்புறம் பிரசிடென்ட் கையெழுத்து போடணும். பிரசிடென்ட் கையெழுத்து போடல அப்படின்னா அதுதான் நம்ம என்னன்னு சொல்றோம், வீட்டோ அப்படின்னு சொல்றோம். அவர் கையெழுத்து போடாம இருக்கிறார், அதுதான் என்ன சொல்றோம், வீட்டோ பவர் ஆஃப் த பிரசிடென்ட். ஓகேங்களா? அந்த வீட்டோ பவர் மூணு விதமா இருக்கு. there are three kinds of veto to the president: absolute veto and suspensive veto, அதுக்கடுத்து வந்து பாத்தீங்கன்னா packet veto. Okay, in the absolute veto is a concept practiced in England. See, the England has two types. One, parliament. The second is king. If the parliament has made any hasty, then the king can veto the thing. But what happened is, now the England has the procedure of cabinet form of government. That is, both the initiation of law and the execution of law are done by the cabinet and parliament. So this concept becomes obsolete, right? Because the executive, the cabinet. So, hello. Hello. See, the king is considered as an executive, right? Whereas the parliament is a legislature, right? So the domain of legislature is law making. Okay, whenever if the law made by the legislature becomes something not good, then the president, that is the king, can veto that. This is the concept on which basis the absolute veto was formed. But once the polity of the England becomes cabinet driven parliamentary form of government, the cabinet is an executive, right? The parliament is an legislative. Since the executive also participate in the law making, the concept becomes obsolete and it was not used in England right now. But India also hold the cabinet-driven parliamentary form of government, but we have the concept of private member bill. What is the private member bill means? The bill introduced other than minister are called the private member bill. So the absolute veto can be used only for the private member bills. Okay. So this is called absolute veto. This veto cannot be exercised by the president without the aid and advice of the council of minister headed by the prime minister. Okay. The second one is pocket veto. Pocket veto is the concept practiced in America. In America, they follow the presidential form of government plus the concept of separation of power. That is, legislature, executive, and judiciary are independent and equal. Correct? If the legislature passes an act to destabilize the executive, then the executive can veto the bill. Okay. So this is given to the power given to the president in the American polity. That is, he has to take, normally the American president has to either give assent or reject within 10 days. But if he has not taken action during those 10 days, then it can be considered he has exercised the packet veto. Okay. But in Indian circumstances, then there is no time limit has been given. It is only mentioned as soon as possible. Okay. So this is called packet veto. Suspensive veto means Lok Sabha, Rajya Sabha. See, a bill has been passed in Lok Sabha and Rajya Sabha. Now it has come to the assent of the president. But what the president has done is he didn't sign it. He didn't reject it. Okay. Whereas he returned it to the house where it was originated. Please reconsider this bill. Okay. Now the Lok Sabha can change or without change it can pass the bill again and it sends to the Rajya Sabha. In the same manner, Rajya Sabha has also passed the bill and it now again sent to the president. Now the president has no choice. He has to sign. Okay. That is one-time reconsideration of the bill is called suspensive veto. You should not confuse the suspensive veto and the aid and advice that we have seen in the initial of this class, right? These two are different. This is with respect to executive's aid and advice. This is with respect to the legislature's bill. Okay, suspensive veto and aid and advice binding on the president is not the same, right? Okay, so now we will discuss the veto power of the Indian president. Once, if the bill was passed by both the houses, Lok Sabha and Rajya Sabha, then it comes to the president. Either he can give the consent, that is, he can give the signature, that is assent. He can withhold, that is, he should not give assent. It leads to two things. Okay, one is packet veto, another one is absolute veto, right? Packet veto means taking no action for indefinite period of time. Absolute veto means using this power on the aid and advice of the prime minister, it is rejected. Okay. Another option he has is return, that is suspensive veto. So, according to the Indian Constitution, the Indian president is either he can give the assent, otherwise he can withhold. Withhold means not giving assent. Kindly pocket or absolute veto. Another one is suspensive veto, that is he can return the bill for reconsideration. But this is not available to the constitutional amendment bill. Okay, the veto power is not applicable to the constitutional amendment bill. There are many kinds of bill: ordinary bill, financial bills, money bill, constitutional amendment bill. Okay, veto power is not applicable to constitutional amendment bill. He has to sign. It was made by 24th Constitutional Amendment Act of 1971. But all other bill has veto power. Okay, ordinary bill, finance bill, money bill. Okay. See, with respect to ordinary bills, the president can ratify. That is, he can sign. Otherwise, he can reject. Otherwise, he can return. He can do all the option with respect to ordinary bill. With respect to money bill, either he can give the assent. That is, he can give the signature. Otherwise, he can reject. Okay. But he can't reconsider. Okay. There is no suspensive veto for money bill. There is no possibility of constitutional amendment bill. He can only give the assent. Now, veto power over state legislation. That is the bills of the state legislature, legislative assembly. If it is ordinary bill, it is to the governor. If the state legislative assembly, right? The state legislative assembly, if it has the state legislative council, in the both houses it has been passed and given to the governor. Either he can sign or he can reject or he can return or he can reserve for the president of India under article 200. Okay, he has 4 options. Okay, if it was same for the money bill also, he can ratify, he can reject, or he can reserve, but he can't return. Okay, there is no possibility of constitutional amendment bill in the state legislature because it is only the parliament has the power to amend the constitution. Okay, now we will consider, suppose the governor reserve the bill for the consideration of the president, that is the ordinary bill and the money bill. What will happen? Okay, if the governor reserve for the president has 3 options with respect to ordinary bill, that is ratify, reject, return. Okay, either he give his assent or he can reject, that is absolute or packet veto, or he can return, that is suspensive veto. With respect to the money bill, either he can give the signature or he can reject, but not return. Okay, suppose the ordinary bill, the president exercises suspensive veto, the state government should amend. If they didn't amend the provisions, then again it passed to the state legislative assembly, then president's veto cannot be overridden. But in case of parliament, it is overridden. But in case of state legislative assembly, it is not overridden, right? See, what I am trying to explain you is, if the Lok Sabha passes, Rajya Sabha passes an ordinary bill and given to the president. Now the president exercises suspensive veto. That is, he sends to the house where it was originated and said that reconsider the bill. Now Lok Sabha has 2 options. One, changes, otherwise no change. It again, suppose we will consider no changes. Okay, it again passed and sent to Rajya Sabha. Now Rajya Sabha also again passed and sent to president. Now the president has no choice, he has to sign. Whereas in the state legislative assembly, for example, in any state, there are 2 houses. Okay, state legislative assembly and state legislative council. If it has, okay, it has been passed by state legislative assembly, it has been passed by state legislative council and sent to the governor. Now the governor has 4 options, right? One, he can sign, ratify, he can reject, okay, he can return, or he can reserve for the president. Now what he is doing, he can reserve it for the president. Now the president has the same option, that is he can ratify or he can reject or he can send for reconsideration. Now the president exercises this option, it is given for reconsideration. Now the state legislative assembly has to modify the provision. But if the state legislative assembly does not modify and pass it the same, and it is also again passed the same by the state legislative council, then it will not go to the governor, it will go directly to the president. And the president is not bound by the bill. Okay, he will not give the sign. That is what explaining in the point. That is, no overriding powers to state legislative assembly on president veto, whereas the parliament has the overriding power, but the state legislative assembly has no overriding power. Okay, the next is pardoning power of the president. Other than constitutional amendment bill, president enjoys absolute veto. If yes, then money or ordinary bill cannot be passed easily. Yes, you have to understand one thing. See, president has absolute veto, right? Absolute veto can be exercised only on the aid and advice of the Council of Ministers headed by Prime Minister. He can't exercise it on his own, but he can exercise the pocket veto on his own. Yes, you are correct. If the president exercises the packet veto, it is difficult to get past the bill, but it will not be the case, right? Because if it has any problem, then only it has to be used. But this packet veto was, the nature of packet veto is for the purpose of, it is the concept of American, right? See, in America, the legislature, executive, and judiciary are independent. That is, they follow the separation of power, right? If the legislature wants to uh, make the bill that worsen the position of the president, then the president can use the veto power. They also have the time limit, but in India we don't have the time limit at all. See, these are the rare options. Okay? This will not be used for the limiting the power of the parliament. Okay? But yes, your assumption is correct. It was like that only. If the president exercises that, then there is no options, but it is not used. Okay? So the next is, we will talk about the pardoning powers of the president. It has given in the Article 72. See, the president pardon means மன்னிக்கிறது, ஓகேங்களா? The president to grant pardon to person who have been tried and convicted of any offense in all cases where, அதாவது என்ன சொல்றாங்கன்னா, the if the punishment union law, பிரசிடென்ட்டுக்கு எந்தெந்த அதிகாரத்துக்கு யார் யாருக்கெல்லாம் வந்துட்டு பார்டன் மன்னிப்பு வழங்கலாம் அப்படின்னு பார்த்தீங்கன்னா, சென்ட்ரல் கவர்மெண்டோட லாஸ், கோர்ட் மார்ஷியலோட லாஸ், டெத் சென்டென்சஸ், ஓகேங்களா? See, the president can grant pardon on 3 cases. If the offense is committed under any union government law, if the offense is conducted under the court martial, that is by the sentence is given by the military court, or the sentence is the death sentence, even if it was in the state law. Okay? So then the president can grant pardon. So the pardoning powers are 5 different types: pardon, commutation, respite, remission, reprieve. Okay. The same powers are given to the governors under Article 167 under the state laws. He can to issue for the state laws. Okay. Pardoning means there is two words. Okay. One is sentence, another one is conviction. See, pardon means completely set the person free. Suppose a person was awarded the sentence of 5 years, say sentence of 5 years, okay, rigorous imprisonment, okay, sentence of 5 years rigorous imprisonment. The pardon means completely setting the person free and release of that person. Okay, that is called pardon. That can be done by president under the union law, right? Union law, court martials. That is, the person state was completely reversed. That is, before he was arrested, that state can be revived. Okay, that is called pardon. The second one is commutation. Commutation means changing the character of the punishment. For example, rigorous imprisonment to simple imprisonment, right? The change of character of the punishment is called commutation. Remission means changing the duration, 5 years to 2 years, like that. Changing the duration of the punishment is called remission. Respite means both the remission as well as commutation, changing the character and time. It is only special circumstances, like that. Suppose a person is physically challenged or a pregnant woman, like that. In that condition, the respite will be used. Reprieve means stay of execution. Okay, there is a temporary stay on the execution of the order. It is used for the death sentences. To delay the death sentences, this pardoning power is used. Okay. So Supreme Court has given number of guidelines with respect to the pardoning powers of the president. So the mercy petition, okay, the petitioner has no right to an oral hearing by the president. அதாவது பிரசிடென்ட் வந்து நேரம் என்கிட்ட கேட்கணும் அப்படின்ட்டு உரிமையா கேட்க முடியாது, ஓகேங்களா? So the president can examine the evidence fresh and take a different view taken by the court. That is, in the same evidence what the court has used, the president can investigate the same evidence and take the fresh view different from that of court. that power has the president. Okay. The power is to be exercised by the president on the advice of the union cabinet. That is, the cabinet has to be decided. Okay. That is, it is not the discretion of the president. The president is not bound to give reason for his order. Okay. The president has no need to give any reason before the court of law. The president can afford relief not only from a sentence that he regards harsh, but also from an evident mistake. Okay. So if the court punishes a person, the president can give the mercy, right? Not only on the point of harsh, but also if there is any mistake, then also the president can give relief. Okay. So the Supreme Court has no need to lay down specific guidelines for the exercise of this power. Okay. The exercise of the power by the president is not subject to judicial review, except if the decision is arbitrary, that is arbitrary or unreasonable or like something like that. Then the judiciary can intervene. Otherwise, the judiciary will not intervene. Where the earlier petition for mercy has been rejected by the president, stay cannot be obtained by filing another petition. Okay. It is especially in case for the death sentences. Okay. If suppose a person has been applied for the mercy petition to the president, it has been rejected, then the person can't apply for the another mercy petition. But they can apply another mercy petition on different grounds. Okay. Then that it is possible. Okay. So this is all about the pardoning powers of the Supreme Court. So now we have seen. See what we have seen. We have seen in the today class, we have seen three different powers of the president. One, pardoning power. Second one is the emergency power, right? And the veto power of the president. The remaining one most important power is the ordinance making power of the president is remaining, right? We have to see that. We have to see that. Okay, we have completed this, and also we have completed the basic things. Right? That is the election and removal of the president and all we have seen. See, the death sentence, even if it is available under the state law, it has to be pardoned only by the president. But there is a difference between pardon and commutation. Okay, commutation, reprieve, respite, these are different. Pardon means completely setting the person free. This power is only available to the president for the death sentence. Okay. But the remaining are available for the remaining are available to the governors. That is, I hope your doubt will be clear, right? So that's all about the today's class. So if you have any doubt, you can ask in the chat box. Okay, friends, that's all about the today's session. We will end the session. Article 143 is a presidential reference. That is, if the president has confusion about any view, then they can ask the opinion of the Supreme Court. Sir, okay, sir, we will discuss that too, sir. No problem. Sir, if you want to discuss now itself, we can discuss, sir. No issues, sir. You are talking about that 10 questions, sir.
Yes, sir.
Okay. If you Okay, sir. Now we can discuss it. See, Article 143 is called the presidential reference. Okay, what does it mean is it is the if the reference is for the president means that is even the council of ministers headed by the prime minister has the confusion relating to certain topics, then they can make representation to the Supreme Court. Okay, it is to avoid the legal conflict between the executive and the judiciary. Okay, the legislature and executive on the one hand and judiciary on the other hand to avoid this. For example, the National Judicial Appointment Commission Act has been passed by the Parliament, but it was struck down by the Supreme Court. If the opinion was held, the opinion has been asked by the legislature or executive through the president using Article 143, then Supreme Court can hold its view, then this kind of conflict can be avoided. Okay, but this was used for the key, that is to get the opinion of the Supreme Court in key issues. Okay, for that the Article 143 was used. Uh, by using Article 143, the president can have the opinion of the Supreme Court. Okay, but it is not binding on the Supreme Court to give the opinion compulsorily. Okay, they can give or they don't give. Okay? It is not binding on the Supreme Court. If the Supreme Court given the opinion, then it is not binding on the president to follow. Okay? Either they can follow or they can't follow. It is just to find out the view of the Supreme Court on that particular issue. This was used. Okay. Okay. So now we will start with the question discussion, right? See, consider the following statement, right? The aid and advice tendered by the Council of Ministers is not binding on the President before 42nd Constitutional Amendment Act. Is it true? See, no, it was true, not true, right? It is even before the 42nd Constitutional Amendment Act. It is binding on the President by the judicial thing, but it was only made by the Constitution in the 42nd Constitutional Amendment Act. The second one, the President can dismiss the entire Council of Ministers on the advice of Prime Minister, whereas dismiss the individual minister on his own. No. See, the President can dismiss the entire Council of Ministers on the advice of Prime Minister, right? This is correct. Whereas dismiss the individual minister on his own. No, it is wrong. Okay. He can dismiss the individual minister on the advice of the Prime Minister. Okay, so the both are wrong. Okay, so the option is none. None of the following. The second question is consider the following statement. See, nice. Okay. See, first statement, consider the following statement. The aid and advice tendered by the Council of Ministers is not binding on the President before 42nd Constitutional Amendment Act. See, the option is not correct because we have seen that the Dr. Rajendra Prasad itself made the presidential reference to the Supreme Court. In that, Supreme Court held that the aid and advice is binding on the president since we are following the parliamentary form of government. The president is the nominal executive and the Council of Ministers headed by the Prime Minister is the real executive. So it was the judicial thing that ensured the advice is binding on the president. But only the 42nd Constitutional Amendment Act made it constitutionally. So it is even before the 42nd Amendment Act, it was binding on the president only. So the first statement is wrong. The second statement, the president can dismiss the entire Council of Ministers on the advice of the Prime Minister. Yes, the statement is correct till now, but whereas they dismiss the individual minister on his own, no, it is wrong. Okay, the Prime Minister, the president can dismiss the individual minister only on the advice of the Prime Minister. He cannot dismiss the individual minister on his own. Okay? So the both statements are wrong. The option is none of the following. The second question. Consider the following statement. The president can be impeached from the office only for proved misbehavior. No, it is wrong. We have seen that the president can be impeached only for the violation of the constitution, right? So there is no concept of proved misbehavior to the president. It is for the judges. Okay. So the statement is wrong. It is only for the violation of the constitution the president can be impeached from the office. The procedure for the impeachment of the president is given in the constitution. No, the procedure is not given in the constitution. Right? Sorry, the procedure for the impeachment of the president is given in the constitution under Article 61. Right? So the option is 2 only. Right? The second one, third one. Consider the following statement. The salary of the president is credited from the Consolidated Fund of India. Yes, the statement is correct. Every year in the budget session, the parliament will vote upon the salary of the president. No, it is wrong. Right? It will not be vote, it is charged upon. Right? The parliament can increase or decrease the salary of the president even after his appointment. No, it is also wrong. Okay? So the option is one only. Right? C. It is credited from the Consolidated Fund of India. The parliament will not vote upon. Okay, because it is charged to secure the independence of the president office. It was charged. That is, it is discussed but not voted by the parliament. Okay. The parliament can either increase or decrease the salary, but it is before the appointment. After the appointment, the salary cannot be decreased because it will be disadvantage to him and his independence will be curtailed, so that the parliament cannot decrease the salary after his appointment except a financial emergency. Okay? So the third statement is also wrong. The option is one only. Okay? That the president can use the suspensive veto without the aid and advice of the constitution. Yes, it is correct. Suspensive veto can be used without aid and advice of the constitution. That is one time. That is reconsideration of one time. The statement is correct. The president cannot veto the constitutional amendment bill. Yes, this statement is also correct because the 24th Constitutional Amendment Act made that the president can't veto the constitutional amendment bill. Before that, he can veto, but after that, he can't veto. Right? So the both statements are correct. So the answer is both. Okay. Now the fifth question: separation of power is the basis of federal constitution. Is it? No. You have to understand it clearly. See, there are two things. Separation of power is the basis for federal constitution. Distribution of power is the basis for the parliamentary form of government. See, separation of power is basis for the presidential form of government, not the federal constitution. Okay. Separation of power talks about the distribution of power between, separation of power talks about the separation of legislative, executive, and judicial organs. It is not talks about the distribution of power between the central government and state government, right? So the first statement is wrong. The second statement talks about the distribution of power is basis for the parliamentary form of government. No. The basis for the parliamentary form of government is executive remains responsible to the legislature. Okay. Distribution of power talks about the federal. Okay, separation of power talks about the presidential form of government. Parliamentary form of government means executive remains responsible to the legislature. That is fusion of power. Okay, so both the statements are wrong, and the option is none. Okay, consider the following statement. To form the government, absolute majority is required. Yes, correct. That is, we have seen that out of 543 seats, it has to require the majority of 272 plus. That is absolute majority. Correct. The statement is correct. To remove the government, simple majority is required. Yes. To remove the government, you have to you have to pass the no confidence motion, right? The no confidence motion requires only the simple majority. The both statements are correct. The answer is both the following. Okay. Consider the following statement. Under Article 368, two-thirds of the majority of the House is required to pass the bill. See, two-thirds of the majority of the House is required to pass the bill. It is wrong. It is two-thirds present and voting. Half of the total strength of the House is required to pass the bill. Okay, it is wrong. The ordinary bill requires only half of the majority of the House to pass the bill. Half of the majority of the House. It is wrong. Okay, it is only half of the present and voting. Okay, so both statements are wrong. Eighth question. Presidential system of government is suitable only with the federal constitution. No, it is wrong. In both federal and unitary, presidential system or parliamentary system can be formed. Okay. The presidential system is related to this separation of power between the legislative, executive, and judicial organ. It can be practiced in both unitary as well as federal model, right? There is no such thing. Right? Parliamentary form of government is suitable in both unitary and federal. Yes, the statement is correct. You can follow the parliamentary form of government in both unitary. For example, unitary Britain, federal India, they both have the parliamentary form of government, right? The second statement is correct. The answer is 2 only. Okay. Consider the following statement. President is the head of the government. No, president is only the head of the state. Correct. So this is wrong. Indian president is the de facto. No, we have seen that Indian president is the de jure. That is nominal. Okay. Indian president can be removed by Supreme Court. No. We have seen in the removal process, he can be removed by the parliament. Right. So this is also wrong. This is also wrong. None of the above is the correct option. Right. Consider the following statement with respect to the qualification of the president. Okay. Qualification of the he should be completed 35 years of age. Yes, correct. He should be the citizen of India. Correct. Eligible to be appointed as a member of October. Yes, correct. All the above. All the options are correct. Okay. So this is all about the questions. If you have any doubt, you can ask me in the chat box. See, these are the questions are standard. If you are able to solve these questions, you have understood the concept well. Okay, especially this question, separation of power is the basis for. These are basics. If you have the confusion with this kind of question, then you can have to work out the basics. Okay. If you have any doubts, please ask me in the chat box. If you are carefully watching the class, you do not need the study of NCRT, but you have to study the Lakshmikant because all the points cannot be explained in the class or PowerPoint. You definitely you have to read the Lakshmikant. See, legislative executive powers are different powers given to the president. For example, the veto power is the legislative power of the president. Pardoning power is the judicial power of the president. Right? Emergency powers are executive powers of the president. Okay. The different powers can be classified under different heads. Okay. Any other doubt with respect to this question? 10 questions. Okay. I hope You have no doubts at all? 5. Yeah. Okay. We have seen in that to become the president, eligibility requires 35 years of completion, eligible to be appointed as the member of Lok Sabha, and he has to fill other criteria. So he has to be the citizen of India. The fifth question talks about, one second, I will share it. See, the fifth question talks about the separation of power, okay, separation of power and the distribution of power. See, the fifth question talks about the separation of power is the basis for federal constitution. Okay, we have seen that, we have studied that federal means distribution of power between central government and state government. Separation of power is basis for the presidential form of government. It is not the basis for the federal constitution. Separation of power talks about the separating the powers between the legislature, executive, and judiciary. Separation of power is the basis for presidential form of government, and the presidential form of government can be practiced in both federal constitution as well as the unitary constitution. Okay, first thing you have to understand is, wait a minute, I will explain it better. Oh, I will show it. Don't worry, Faisal. See, first we will discuss the fifth question because it is very basic. See, there are 4 words. Okay. One is unitary, second one is federal, parliamentary, and presidential. Clear? Federal means the distribution of legislative and executive function between the federal or central government and provincial or state government is done by constitutionally and not by means of any other act. That is, the distribution of the both legislative and executive power has been divided between the central government and state government by constitution itself. It should not be done by parliament or any other. Okay, it should be done by constitution. That is, federal means division of power between central and state governments. That is called federal. Okay, that should be clear first. That is, whenever the chapter of president, Sikandar, you have to study the chapter of president. I think the chapter number is 18. So the distribution of power between the central and state government. That is this is called federal. Okay, if the power has been divided between the central government and state government, then the constitution is called federal constitution. Okay. Unitary means there is no existence of two governments. First of all, there is no central government and state government. There is only one government. Okay, that is called central government. Then this kind of constitution is called unitary. For example, the Constitution of England is unitary. Okay, whereas the Constitution of America is federal. Clear? See, Government of India. Okay, Government of India means central government. State government means Tamil Nadu, Kerala, Karnataka. These are called state government. They have the constitutional distribution of powers. Okay, so Indian constitution is called federal. Okay, that is, see, for example, Government of India deals with military, diplomatic, currency, coins. This, okay, this kind of powers are dealt by Government of India. Whereas agriculture, land. These are the law and order. These are the issues to be dealt in state level. So these powers are held in state governments. That is, the division of power has been done by constitution in the seventh schedule. Okay, seventh schedule has three lists: central list, state list, and concurrent list. Okay, so the power is divided here. So the constitution of India is federal. Okay, whereas you can see that the relationship between the government of India or state government with respect to the district administration. District administration is called the district collector office, right? It is the appointed body. It is not the elected body. It does not have the mandate of the people. Okay. So this is the concept called unitary. Unitary means there is only one government. They can have an administrative agency, but they don't have government. Okay. That is the difference between the unitary and federal. The basis for the federal is distribution of power. Okay. To understand the presidential versus parliamentary, it is the separation of power. The presidential form of government talks about the legislature, executive, and judiciary. These are three organs of the government. It has to be separated. The powers of the legislature and executive and judiciary are separated. In the parliamentary form of government, executives are emanated from the legislature, so it cannot be separated. So that it is called a fusion of power. Legislature and executive will be in one group, and judiciary will be separate, right? So the parliamentary form of government has the fusion of power. The fifth question we have discussed that separation of power is the basis for the federal form of government. The first statement of the fifth question is separation of power is the basis for federal government. Is it? No. Distribution of power is the basis for federal government. Separation of power is the basis for the presidential form of government. Fusion of power is the basis for the parliamentary form of government. But we can't use the term fusion of power, whereas we can use that executive remains responsible to the legislature is the cardinal principle of parliamentary form of government. Okay? So separation of power related to the presidential form of government. Executive remains responsible to the legislature is the cardinal principle of parliamentary form of government. Distribution of power between the central and the state government is the basis for the federal government. Okay, it has to be clear, right? And one more thing. See, unitary and federal talks about the distribution of power between the central government and state government. Presidential and parliamentary talks about the relationship between the legislature and the executive. The presidential and parliament talks about the relationship between the legislature and the executive, whereas the federal talks about the distribution of power between the central and the state government. It should be clearly fixed in your mind. Okay. See, it is possible. Okay, in the unitary constitution, both parliament as well as presidential model can be practiced. In the federal constitution, both presidential and parliamentary model can be practiced. For example, federal presidential United States of America. Okay, federal parliamentary, the example is India. Okay, unitary parliamentary example UK or England or Britain. Okay, unitary presidential we can call uh, China, but the China's power is linked by constitution. Okay, but the working style is similar to the unitary presidential. Okay, so this is the basic difference. I hope now it has been clear. See, This is the qualification for the election as a president. A person to be eligible for election as a president should fulfill the following qualification. First one, he should be the citizen of India. He should have completed 35 years of age. He should qualified for election as a member of Lok Sabha. That is, what is the qualification of the member of Lok Sabha? That qualification has to be fulfilled by the president. Okay. He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. Okay. Office of profit means he should not receive salary either honorably or the working salary under the union government or state government or local authority or any other public authority. A sitting president or vice president or the governor or any minister is not deemed to hold any office of profit and hence qualified as a presidential candidate. Actually, these offices are the office of profit, but for the purpose of the election of the president, these are considered as not office of profit. That is, these are the exception made to the office of profit for the purpose of presidential election. Okay, so these are the qualification for becoming a president. Clear? So, any doubts? Any other doubt? So clear. Yes, sir. We can wind up the session.